Good afternoon,
Good afternoon, Judge.
Mr. Rayo.
Yes, let me do this.
There you go.
Good afternoon.
Good afternoon,
Hey, perfect. I'm usually
sir.
in kindergarten and all this stuff, but I found my way.
Excellent. Well, I'm glad. So, gentlemen, we are
Thank you.
here on a um, motion for summary judgment in the matter of ASM Holdings versus Ali Muhammad versus Assets and Equity LLC. As I understand this case, um, excuse me, Mr. Muhammad and ASM Holdings 64 filed this action against Assets and Equity, arguing that they had violated the automatic bankruptcy stay, that the company had violated, had engaged in wrongful foreclosure, and violated the Fair Debt Collection Practices Act. The defendants, Assets and Equity, has come forward and filed a motion for summary judgment, seeking a judgment in its favor on the entire action. And as I think I understand it, the two real issues are one that I may mess this up. And so once I finish reciting what I think I know about your case, then I'm going to throw it over, Mr. Phillips, to you because it's your motion to correct or educate me about anything that I've said wrong or that I need to know. And then, of course, obviously, Mr. Rail will be given an opportunity to respond. So I believe my understanding is really two issues. Number one is that the plaintiffs take issue with the fact that Assets and Equity allegedly is not registered to do business in the state of Georgia. And then separately, I think I understood that it was Mr. Muhammad filed bankruptcy at some point. But the corporate entity who allegedly is the actual owner of the property that was foreclosed upon, or the guarantor on whatever was foreclosed, had not filed bankruptcy. And so I think I understand Assets and Equity's position to be, number one, that the fact that Assets and Equity is not registered to do business, maybe. I don't know the answer exactly to that, but even if it's not, that it doesn't change the outcome here. It doesn't negate their right to foreclose on a property interest. Number one. And number two, that there was no applicable stay because ASM Holdings was not in bankruptcy and therefore they were not prohibited from foreclosing his interest. That's what I think I know about this case. Mr. Phillips, I'm going to throw it over to you. And last thing I'll say is, well, two things. One, we don't have a court reporter, just so y'all are clear, because y'all didn't ask for one. And so we don't have one. And number two, I didn't get to eat lunch. So you might see me eating pretzels while you're talking. I'll try to be very polite about it.
Is that number two?
Yes, sir. But with that, I
I
will
need
hand it
that
over.
too. Yeah. Okay.
I will hand it over to
Okay.
Mr. Phillips
Sorry.
since
Go
it's your
ahead.
motion. Go ahead, sir.
Yes, ma'am, I will. And first, I'd like also, Your Honor, make just objection. As you said, we don't have a court reporter, but we do have the record itself. And the affidavit that, and the defendants, the plaintiffs did not file any response to the motion for summary judgment until last night after 10 o'clock p.m. And the court order that specifically requested, reset this case, specifically required that all documents, everything that had been filed, be sent to your staff attorney at least one day prior. And so I believe that revises the law with respect to the fact that an affidavit can be filed one day before, in view of the fact that it was not served on me until I received it through Odyssey this morning. It's also interesting that the affidavit is dated February 3rd, but it wasn't filed last night until after 10 o'clock p.m. And then the response to the motion for summary judgment, which was required to be filed within 30 days, there was no order saying that extending that time, despite the fact that the court granted a continuance request. And it was actually signed by Mr. Rail on January 3rd. It's got a certificate of service of January 3rd, which it was not served on me on January the 3rd. It was served on me this morning via Odyssey. So I just like to point out that like everything else in this case, the plaintiffs have not followed your court's orders, scheduling orders, and have not followed the law. And so therefore I'm just putting those objections to you, although there's no transcript, no question about that. With respect to, just to clarify the bankruptcy issue, Your Honor, as a matter of fact, ASM filed bankruptcy several times. There were several letters sent notifying, and actually the foreclosure advertisement was actually filed several times, but ASM filed bankruptcy several times, and then it was actually dismissed several times. And then finally, in December, a new notice was sent out. No bankruptcy was filed, and this is in December, Your Honor, 2024. No bankruptcy notice, no bankruptcy was filed by ASM. I guess they figured, 3 strikes were out, we may be in trouble. So the day before the foreclosure, Mr. Muhammad filed bankruptcy. And under the bankruptcy law, which is the order set that we've attached to our motion, Mr. Rail has said that was entered after the foreclosure. Well, obviously it was entered after the foreclosure because the bankruptcy wasn't filed until the day before the foreclosure. But it actually said that the stay under 341 of the bankruptcy code, Your Honor, did not affect the foreclosure because Mr. Muhammad was a guarantor and it was not part of the estate of the debtor, ASM. So therefore, there was no prohibition on the foreclosure going forward. With respect to the issue of whether whether Assets and Equity was required to qualify to do business in Georgia, Mr. Rail has actually filed something and cites a code section dealing with actions in court. And he does not even respond at all to the code sections that I replied to with respect, because he also raised it with respect to the prior obligor under the prior payee of the note, because it was a corporation, foreign corporation, and then the LLC, which is the defendant in this case, is a foreign LLC. But in both of those, there's an exception that I actually cited the code section that says that you're not required to qualify to do business in Georgia merely because you loan money, and so therefore there was no requirement that this company, my client, qualified to do business in Georgia in order to conduct a foreclosure, which it did. It's interesting, Your Honor, that Mr. Rail was actually the registered agent receiving all these notices about this and took no action whatsoever to stop the foreclosure. If he felt there's anything wrong about it, he got notices plenty of times, including December, and did not file anything with respect to the foreclosure, and did not, in respect to the dispossessories, did not seek to enjoin the dispossessories while this case was pending in terms of his claim that there was a wrongful foreclosure. And so as a result, there were dispossessory orders entered with respect to both properties, and the occupants of those properties were actually evicted, and one property still sits vacant because of it hasn't sold yet.
And just to make sure I'm clear in terms of the background facts, although I assume, based on the initials ASM and Ali Muhammad, that Ali Muhammad is a principal of ASM Holdings 64 LLC.
That's my understanding, and that's what he says in his affidavit that he filed last night after 10 o'clock.
Right. But my understanding is that ASM Holdings is the owner that was foreclosed upon, correct? That Mr. Muhammad was he a personal guarantor?
Mr. Muhammad was a personal guarantee of notes.
Okay.
ASM was only owner of one property.
Mm-hmm.
Mr. Muhammad had transferred the other property, the second property, and I believe it was Adams Drive. I get them confused, Your Honor. I think, and that's the one that has already been sold to his daughter without notice to us. And so therefore there was no notice published in the newspaper with respect to the foreclosure of that property, giving notice to his daughter about that, because there was no notice to the lender of the fact that it had been transferred.
Thank you, Mr. Phillips. You can continue.
So I think that addressed both of those questions that you had, as I understand it.
You did. I just wanted to, I appreciate you directly answering my 2 questions, and then wanted to give you an opportunity to sort of make any further or additional argument you think is necessary? Obviously, you'll get an opportunity to respond because it's your motion, so I'm going to let you have the last word.
Yes, ma'am.
If you're concluded, I'll call on Mr. Rael. If you have any other thing to add, let me know.
Well, as I said, I didn't get the response until today, although it was signed on January the 3rd. But I've read it as well as the affidavit. I don't think that either one of those destroys the basis upon which the motion for summary judgment has been filed with respect to lack of standing by both ASM, ASM with respect to the property that had been transferred to Mr. Muhammad's daughter, and then with respect to Mr. Muhammad, he had no standing whatsoever with respect to either property because he was not the owner of the property at any time. He was just merely guarantor. There was no requirement that he actually be sent notice, and that's actually in the argument itself, that somehow or another there's no evidence that in fact no notice was sent to him of the foreclosure. Well, they haven't cited any code section. I'm not aware of any code section that requires that the guarantor be sent notice of the foreclosure, although ASM, as a practical matter, is Mr. Muhammad. And so I think it kind of begs the question to argue that notice wasn't sent to him as many times as it was sent to ASM. Also, one of the I think there's only one case cited by Mr. Rael in his brief. It has no citation whatsoever, Your Honor. I believe I know which case he's talking about, but in that case, does not stand for the proposition for which he cited it. And then with respect to the foreclosure itself, Your Honor, I cited the United States Supreme Court case that says you don't have a violation of the Fair Debt Collection Practices Act by filing a foreclosure. And so I think those hits. We've already hit the requirement to be registered to do business in the state of Georgia in order to foreclose. Don't have to do that. We've already hit the fact that the bankruptcy of Mr. Muhammad did not prohibit the foreclosure because Mr. Muhammad, it was not part of his estate, so therefore there was no stay in place. We've hit the Fair Debt Collection Practices Act, and so I think we've hit every single argument that has been asserted in the complaint. Although discovery is pretty limited in terms of the information provided by Mr. Rael ultimately, and then with objections, despite the court's express orders not to put objections in the discovery. So that's it.
Understood. Thank you very much, Mr. Phillips. Mr. Rael, your response, sir?
Okay, you can hear me. First of all, Mr. Phillips is right. He just got it yesterday, so he'll have time to go over that and look at what he has to do when he has the time to do it. Second, yes, he's right also that maybe it should have been filed even earlier. Right now I'm having some trouble. I actually have tomorrow a specialist that I have to go to, but I postponed that because of this court thing at 9. And it's been, by the way, it's taken me months to even get this appointment, but I thought it would be good to go before the court. And instead, of course, it's already postponed it once. It seemed like thing to do, and I can always go to see the specialist another day. But that has a lot to do with why Mr. Phillips is wondering how come it's not in 30 days and 31 days and 40 days, and why is he just getting the answers today? But also, he's saying to us that why couldn't I have stopped the foreclosure? First of all, I don't do bankruptcy. I do a lot of murder cases and criminal cases, and that's what I do. I only got involved with Ali Muhammad because he promoted a fight and he was Muhammad Ali's fight as a result. And then on top of that, he made me a co-producer of. He did a movie, and I had done a movie years before that, so he got me involved. By the way, that movie is another story for another day. But because of that movie, I was on Dateline and NBC and ABC and this sort of thing. So I got involved in the wonderful world of film. Anyway, the thing is, one of the reasons I didn't do as Mr. Phillips is suggesting, why didn't I file the bankruptcy immediately?
Well, in
I
fairness,
really don't know about that.
in fairness, I don't think that's what he's suggesting. I think what he's saying is that because you've been involved from a corporate perspective with Mr. Muhammad and ASM Holdings, that when these notices were happening, that you were in a position to have made sure that your client was aware of them. I think that's his point. Whether that is dispositive of the outcome or not is a different
Okay.
matter, but I think
Okay.
that's his point.
You're right. Oh, yeah, I think you're right. So I stand corrected on that. But let me get to the issues at hand. The As the court had just suggested, there are really two issues. One is the bankruptcy issue, and second is the issue of did they have the standing to even bring any kind of action right now. So, number one, as to the bankruptcy issue, there's no maybe about the fact that he filed a bankruptcy at the 11th hour. Okay, he did that. By the way, that happens to a lot of people a lot of times when they're about to be foreclosed on. So they do it at the last minute and they go to the bankruptcy court. In this particular case, he did it on, as we said, because he had a guarantee. And that guarantee is very important because of the fact, he says, Mr. Phillips says, that somehow the Ali Muhammad is pretty much the same thing as ASM Holding because he's part of it. Of course, they're two different entities, 100%. No maybe about that. So the entity that was the personal entity had a guarantee. And that guarantee was not something that the Phillips people did anything about. They ignored it. They didn't do anything about his guarantee. What you should do on any kind of guarantee is you tell the guarantor that, and they give them a chance to do something. But he had no
But are they
chance.
obligated to, Mr. Rail? I mean, my understanding of a personal guarantee is not that it imbues anyone with any ownership interest, but that it's actually flows the opposite direction, right? It's a reassurance to the creditor that if I can't enforce or recover my debt from the people who actually owe it to me, here, ASM Holdings, that you, Mr. Muhammad, agree to make me whole. But just because Mr. Muhammad had agreed to that, that doesn't mean that Mr. Muhammad has any ownership stake, right, in the property, does he?
Well, that's a good point. I think maybe the court is right on that. But here's the part that the court has to understand is he decided to file, and he said that he had a guarantee, and he went to the federal bankruptcy court for that. Now, the bankruptcy court could say, as the court is now saying, hey, who cares about his guarantee? Maybe it's worthless, but he did file such a guarantee, such a motion to the bankruptcy court. And maybe in another month, the bankruptcy court would say, hey, this, as we understand uh, guarantors, it's not applicable. We're sorry. But the thing is that court has to make that decision. Once he filed, at that moment, once the hammer came down, once at that moment he filed for a stay, the stay was in place 100%. And that's a fact. So if the stay was in place, they had to stop
Well, so
everything.
here's what I'm trying to understand though, in terms of what the stay does, because I understand it's the, giant blanket of staying everything. I agree.
Right.
But the purpose of the stay is a debtor lists their obligations. And certainly if Mr. Muhammad was a personal guarantor, he would have listed this as an obligation, right? That he would have listed it as a debt of his bankruptcy estate. But if the creditor wants to forego recovery of that debt. Aren't they allowed to? I mean, because really their argument is we're not actually trying to recover anything from Ali Muhammad, right? So we'll let you get rid of that debt in bankruptcy. We're not trying to recover it.
Well, again, there was a guarantee on behalf of Ali Muhammad. We agree with that. Okay. So that would have stopped since he had a guarantee and it was in the bankruptcy court. To me, that stops. Once that hammer comes down, that stops everything until such time as somebody says, you're wrong. The guarantee is meaningless. What the guarantee was something. It was a guarantee. So, therefore, he filed the bankruptcy. And I think he could have filed the bankruptcy. And he did file a bankruptcy. And nobody, until way later, got that bankruptcy dismissed. So, when the hammer came down, that stopped everything 100%. That's the argument.
Okay. Mr. Rail, what
Now,
about the
yes.
issue that your client has asserted regarding the defendant not being a registered entity here in the state of
Okay,
Georgia?
let me get to that, Your Honor. The thing is on that, yes, they have an absolute right to do foreclosure. As a matter of fact, it's in the statute. They can do that. But in this, as I was just now telling the court, they are, let me see where I get that. One sec. Okay. They can do that, but in order to transact business, which they were not they had nothing to do with Georgia. To transact business, that has to be an isolated transaction. That's the only way that it could happen. But they themselves have said that it's not true. They say that they are portfolios managers. That's what they said, not even I. And I'm sure, as a matter of fact, this is a fairly big company. They have a lot of different foreclosures. They have a lot of different things going on in Georgia. Now, that's also a fact. And it can't be denied by Mr. Phillip because it is a fact. So, what is a portfolio manager? I look it up and I see, I don't know, there's no definition of a portfolio manager, but it sounds to me like they are a manager. A manager of what? A manager of portfolios. So, to me, then not doing an isolated transaction, which they're allowed to do, but they're going beyond that. They're being a portfolio manager. And the statute says that they can't do anything except an isolated transaction. So while they could foreclose, and while there's no problem with that whatsoever, there's a big problem with them being a portfolio manager. And it's a big problem with their operating, and they should not operate in Georgia whatsoever. And yet they do. As long as they do, then it's a jury's question, isn't it? Did they go well beyond, or did they not go well beyond what they should do by law? By the law that they're planning to cite to us, that they can go and foreclose? Yes, they can foreclose. The law allows them to do that, but not to be a portfolio manager. No way. That's my argument.
Thank you, Mr. Rail. So I feel like maybe I'm going to let you respond in just a moment, Mr. Phillips, but I wonder, is there I mean, a portfolio manager, as you, Mr. Rail, I mean, I have a general idea of what that is. But I think the idea might be that, you know, you're managing any number of things, debts, credits, whatever assets that would exist in this portfolio. And it may be that assets and equity is managing 50 properties in 50 different states. And we don't really know. I don't think there's anything in the record that would indicate that assets, and other than this fair or unfair, not really sure, presumption based on the title, that assets and equity is engaging in something other than a one-time transaction to engage in this foreclosure. And that's sort of what I'm trying to parse through. Mr. Rail, I think you were concluded. Is that right, sir?
I was concluded, but I'll answer the court
Okay.
problem. And it's true, portfolio manager, what exactly is it, and what is the relationship? And maybe some discovery could have been had, but was not. And that's fair to say. We didn't do all the discovery we should have done. So maybe we could flesh out what they do as a portfolio manager instead of leaving to the court to decide what a portfolio manager really is and what a manager really isn't. And maybe a deposition or two could have been had. So we don't know that. But it seems to me that they've gone beyond what they should do by not being a member of Georgia.
Understood. Thank you, Mr. Rail. Mr. Phillips, your response, sir?
Yes, ma'am. I'm a little bit confused about Mr. Rail's argument with respect to bankruptcy. Matter of fact, I think earlier on he admitted that he's not a bankruptcy lawyer. And so, but he'll.
None of us are.
Well,
Yeah.
actually, I'm not per se a bankruptcy lawyer, but Your Honor, I've been in bankruptcy court a lot, enforcing real estate rights of lenders and also landlords with
So you
respect
know
to
just
tenants.
enough to be dangerous, Mr. Phillips.
Well, that's right, and enough to do.
Yeah.
But I also know that that generally, I believe a bankruptcy judge who enters an order knows what the law is, and so I don't know how Mr. Rail can opine that it stopped everything by Mr. Mohammed filing bankruptcy, because the judge who had the case, which the case, as a matter of fact, if the court looks at the order which we filed with the motion, it specifically said this case was dismissed, not by us. We didn't file a motion to dismiss. Assets and equity didn't. Neither did the lender that actually had filed the foreclosure. It was dismissed because Mr. Muhammad didn't do what he was supposed to do, because all he did was file hoping to stop the foreclosure, and it did. And they didn't. And then they didn't file. They didn't file a complaint to stop the foreclosure beforehand. I have defended plenty of injunction hearings, Your Honor, where they stopped the foreclosure beforehand so they can make these arguments, but they didn't do that. Now, and there's no way around the fact that a guarantor did not own this property. And so therefore, Mr. Muhammad, as the guarantor, cannot say these properties were part of his estate. And that's what the stay applies to. His estate, his asset. Right? Now, with respect to the fact that a guarantee, we have not come after Mr. Muhammad. Now, the bankruptcy that he filed could have stopped us filing a lawsuit to enforce the guarantee. We would have had to go through the bankruptcy court to do that. We didn't do that. We didn't file a lawsuit because we wanted to foreclose on the property. Now, also, Mr. Rail argues all these things that just we all know about asset managers and portfolio managers and things like that. Well, we don't know in this case because there's no evidence that was introduced at all other than what Mr. Rail claims that we all know. Also, Your Honor, assets and equity did not foreclose. The alleged foreign portfolio manager did not foreclose. The lenders foreclosed. The lenders foreclosed as they were entitled to do under the terms of the security deed, which has been attached as part of the motion. And they're not required to qualify to do business in Georgia in order to do that. So both of those arguments that he has made in this hearing fail, period.
One question I have is Mr. Muhammad even a proper party as a plaintiff against assets and equity for any
No,
of the causes of action?
no, ma'am. That's why I raised the fact that he had no standing whatsoever to assert any claim with respect to either one of these properties.
Okay.
And that ASM only had a standing with respect to the property that it owned at the time of the foreclosure.
Right.
But Mr. Muhammad has no standing. So since he has no standing, his bankruptcy is irrelevant, as the judge found, because it was not part of his estate for purposes of the bankruptcy law.
Understood. Thank you, Mr. Phillips. So thank you all very much. I will say a couple things. One, I am generally a stickler for deadlines. And Mr. Phillips correctly points out that the response, despite a reset, that the response wasn't filed until last night late. I was made aware of it first thing this morning. And even then, I don't think it had been accepted into the record when I was made aware of it, although I think it has been accepted into the record now. But I will say that under the circumstances, I don't know that I am required to just sort of blanketly say I refuse to accept the filing as untimely. And primarily it's because even accepting the substance of the filing, I don't think that it defeats the summary judgment motion. Ultimately, the reason I started at the beginning of this hearing with these are the causes of action that were asserted is because it's helpful to me to sort of stay tied to what are the causes of action and what are the elements of those causes of action. And I think as I started, it's important for, hang on, I want to actually look at the document while I am going through it, but I think it is important. I am not persuaded that assets and there's not any evidence in the record as far as I'm concerned to create a factual issue that assets and equity is somehow violating any rules or the law of Georgia, or has no standing to engage in the activities that it engaged in relative to ASM Holdings, because there's no evidence in the record that would create a factual issue as to whether or not assets and equity had engaged in any sustained contact with the state. And as a result of that, I don't think that there is a basis based on the case law that's been cited by Mr. Phillips to find that it's limited involvement in a foreclosure against the assets of ASM Holdings, which it was legally entitled to conduct, that it's doing so in the state of Georgia somehow constituted improper debt collection practice. Excuse me. Hang on just one second. That it somehow constituted improper debt collection practices, or that it constituted, excuse me, a wrongful foreclosure under under Georgia law. And finally, I think that while I understand Mr. Rael's argument, and I think it's an interesting one about the guarantee, the personal guarantee. I think that my understanding, limited though it may be, of the application of the automatic bankruptcy stay is that it attaches to the debtor, and that the asset that was foreclosed upon here was not an asset of the debtor, such that the automatic bankruptcy stay would have attached to prevent the foreclosure action that was undertaken by Assets and Equity. And so that's going to be my ruling. I'm going to grant summary judgment in favor of the defendant, and dismiss the case. I'm not actually dismissing the case. I'm granting final judgment in favor of the defendant. Mr. Phillips, will you please prepare for me, based on the general outline of what I've just stated in terms of the basis for my ruling, a proposed order, that once I receive it, if you'll submit it to Mr. Freehoff in Word format, I will edit it to my satisfaction, and then I will get it on file, and Mr. Rael, you and your client can undertake whatever next steps you decide are appropriate. Anything else questions, any other issues before we adjourn? Mr. Phillips?
Yes, Your Honor, in light of your ruling, although I don't think I'll be able to submit the order to you in time, I'm assuming we're relieved from having to appear before you tomorrow morning at 9 o'clock.
That is correct. You do not need to
Right.
appear for the pretrial conference tomorrow.
Thank you, ma'am.
So then I
Appreciate
can
that.
go to my specialist.
Yes, you should always take
Okay.
care of your health, Mr. Rail. Did you
I
have any
will.
substantive questions regarding the court's ruling or otherwise, sir?
No, I understand completely what the court just ruled and said, so no, I
Okay.
don't.
Excellent. Well, thank you both gentlemen for your time and again for your patience when I was a little bit late getting on. But I will look forward to your order, Mr. Phillips, so get it on file as quickly as I can. And I will see you another time in another matter.
And so as a result of that, Your Honor,
Thank you,
also don't have
Judge.
to worry about, we also don't have to worry about your February 23rd trial calendar either, right?
That is correct. Yes, sir. Although I definitely need the order before then.
Well, I understand that.
Okay.